Welcome, everyone. Thank you for joining us for the latest episode of Kelleher and Holland's Employment Law Lunch and Learn. Our panelists ladling out information today are, instead of three, two attorneys from our employment law group. Unfortunately, Andy Bowling was having technical difficulties this morning, so we will be flying solo without him with the ladies of the employment law group today, Madeline Kelleher, and a new face joining us today, Maura Ann McBreen. She focuses her practice in executive compensation and employee benefits. But our KH Kitchen has been working hard cooking up our topic for today. There are many types of release agreements out there, including releases of personal injury claims, releases to resolve business disputes, and even releases and procedures to settle actual employment litigation matters. But today, we're going to focus specifically on release agreements regarding the separation or termination of an employee's employment in Illinois. So let's start off by talking about what a separation agreement is.
Okay, thanks, Amy. So a separation agreement is a contract between a company and a departing worker, usually an employee, though sometimes it can be an independent contractor, used to set terms when an employee's job ends. Instead of quitting or being fired, which are one-sided decisions, separation agreements can create a mutually beneficial agreement to terminate employment. Typically, the company offers some type of payment, often called severance, or other benefit in exchange for a waiver and release of claims to protect the company from liability. It can also help ensure that an employer's proprietary information and competitive interests remain protected. So in short, I'll do a benefit and for employees and a benefit for employers. So let's start for employers. Separation agreements benefits the employer by minimizing the threat of litigation, guarding against the loss of clients or staff, and protecting the goodwill and reputation of the company. In turn, separation agreements benefit the employee by providing money or some other type of compensation or benefit, ensuring a period of continued insurance coverage, potentially, and offering other benefits, for example, control over how the departure is perceived. But please note that a release agreement does not release a company from criminal responsibility or for conducting any type of criminal activity.
So when is a separation agreement necessary?
So neither the state of Illinois nor the city of Chicago mandate separation agreements. Employers are not required to offer them, and employees are not required to sign anything. However, or nevertheless, really, separation agreements can help the employer and employee amicably part ways. Instead of quitting or being abruptly terminated, both parties can negotiate the terms and decide on mutually agreeable employment end dates. However, among other things, typically employers offer separation agreements in part, if not exclusively, to receive that release and waiver of claims from the departing worker. So it's really essential that an employer have the appropriate language to ensure that the release is enforceable. Employers usually and also frequently use the promise of a severance payment upon termination to recruit top talent and incentivize performance. And if it's drafted properly, the employment agreement should require that a release be signed upon termination of employment to receive such severance. So even though it may seem counterintuitive, the best time to negotiate a separation agreement is often when you're agreeing to join a company, rather than when you decide or are forced to leave. Same on the employer side. And really an important part of any contract negotiation is determining how the parties will act when they part ways. So well-drafted, thorough release agreements can go far to protect your business from legal claims, and many people won't even explore their legal options if they've signed a liability waiver. But it's important to recognize that release agreements do not provide absolute protection. Some claims can't be released by law, such as claims available under worker compensation law or for criminal acts, as I discussed earlier. Other claims, such as deliberate acts that cause injury or bad faith actions, won't typically be covered by a release either. Releases are usually targeted at the effects of negligent actions of the employer. That's pretty much
So
sum up.
Let's keep on this thread, Madeline. So what is technically being released in a separation release agreement?
Right. So the release typically covers claims arising out of anything that occurred on or before the date the employee signs a separation agreement that the employee could make against the employer. The release claims are usually defined broadly, citing every type of claim or liability arising from any conduct that occurred up to the moment of signing. Some separation agreements define the released claims as arising out of conduct that happened either at or outside the workplace, whether they relate to the employment or not. The release usually covers claims that are known or unknown, meaning that even claims that are not apparent until after the agreement is executed, so long as the conduct underlying the claim occurred before execution. So key, before execution. The release may also address pending charges, specifying the court or other tribunal and listing the case number or other identifying information if there is a current litigation or any other type of charge through arbitration or mediation. The separation agreement may require the employee to withdraw or dismiss this charge with prejudice, that is, without the right to file it again later.
And what cannot be released in a separation agreement?
So certain rights either cannot be waived or must be waived with appropriate language, limits, or appropriate procedure. Federal, state, and local law may prohibit any waiver that interferes with their mission. For example, human rights agencies, such as the Federal Equal Employment Opportunity Commission, or EEOC, protect the employee's right to charge an employer with discrimination, retaliation, or other unlawful conduct. Releases may and should carve out such rights. However, employers may also make the employee waive any ability to recover money resulting from such charges. Similarly, the Fair Labor Standards Act protects certain wage claims. The Consolidated Omnibus Budget Reconciliation Act, or COBRA, as many people know it, protects rights regarding continued health care coverage, and the Employee Retirement Income Security Act, or as most people know it as ERISA, preserves claims for certain vested retirement benefits. Most states, including Illinois, protect against a waiver of claims for workers' compensation and unemployment compensation. Other rights must be waived only pursuant to certain required language set forth in federal, state, or local statutes. So, for example, the federal law prohibits an employee from waiving any right or claim under the Older Workers Benefit Protection Act, which is a part of the Age Discrimination in Employment Act, unless the waiver is, quote, knowing and voluntary. So a knowing and voluntary waiver under the Older Workers Benefit Protection Act must, in addition to other requirements, specifically refer to rights or claims arising under the Older Workers Benefit Protection Act. Well, a mouthful. It has to say that the employee doesn't waive rights or claims that arise after the release of the execution date. Advise employees of their right to consult with an attorney, give the employee, at least 21 days to consider the agreement, allow a period of at least 7 days to revoke the agreement. I mean, there's a lot here to cover, and this is just one statute here that I'm talking about. So waivers connected with an exit incentive or other employment termination program under this Older Workers Benefit Protection Act must also provide 45 days to consider the agreement and information regarding the other employees covered by the program, such as job titles, ages, and eligibility, factors for the program. This all has to be included in the agreement, and or this information has to be given to the employee. There's just a lot going on here, so it's really important to make sure that you're very aware of everything that cannot be waived or in a release agreement before you hand it out to an employee or you sign it.
So
Okay,
that
so
was a
Madeline,
lot.
let me
Go
jump
ahead,
in
Maura
here.
Ann, jump in.
I just want to jump in and talk a little bit about 409A. So on top of all the requirements that Madeline has just spoken about, you need to make sure that the agreement complies with Code Section 409A. 409A has a provision that deals with everything under a potential release agreement. So, and there's a common misperception that 409A only applies to public companies or to highly compensated employees. And actually, it applies to everybody. So you need to be very careful. There is a provision in 409A. There's an exemption for uh, uh, certain severance payments that are of a certain amount and that are paid with a certain timeline. There's also an exemption for short-term deferrals, which is probably the greatest exemption at all under the 409A statute. So what you want to make sure is that you organize this as a short-term deferral. There's also an exemption for release payments, for COBRA payments. The problem with the COBRA payment is that if you pay the amount in a lump sum amount to the employee, that could be viewed as includable in income. Although it would comply with 409A, there's a problem because the employee can use it for anything at all. So that as a result of that, the IRS takes the view that that payment is includable in income because you have no strings on the payment at all. The other thing that you could do is you could pay it out, or the employer could provide the benefits under they could just keep the employee in the COBRA payment in the health insurance plan for a period of time. That would result in periodic payments of the amount, which would cover the 409A risk and would still be compliant with the income tax laws.
Great. Thanks, Maureen, for jumping in there.
Sure.
So let's talk about a release agreement involving severance. Must it always?
So severance payments can, or really generally in all contracts, there must be some type of consideration, right? So this means that something each party gets in return for, this contract. Consideration can come in many forms, not just monetary, which we would call severance or a severance payment. For example, separation agreements may also provide for a wide variety of other cash and non-cash benefits the employee is not otherwise entitled to, including payment for accrued PTO, if the employee is not otherwise entitled to this payment. And on this, I wanted to make sure that everyone's aware of the difference between the Illinois Paid Leave for All Workers Act, so requiring PTO, and then Chicago's paid leave ordinances, which under the Chicago ones, I'm positive that there are, under certain conditions, PTO is required to be paid out upon termination. So, and of course, this is only unused PTO. Another non-cash benefit the employee could potentially be used as severance is continued vesting of incentive compensation bonus payments, continued insurance coverage, just like Maureen was talking about under COBRA, outplacement and repatriation services, neutral references, and continued use of certain amenities such as office space, company vehicles, and contact forwarding courtesies.
The other thing that you often put into a release or to a severance payment is a release. So the release would be something where the person is releasing all claims against the company. And as Madeline just pointed out, you need to provide consideration for that release. So you are offering to pay the individual certain benefits as long as they release all claims against the company. The problem with release, again, a 409A issue, is that release must be in one of two forms. Either it's a fixed date release, in which case the person has to forfeit all payments that are not made or that are not paid by the time that the release is due if they haven't provided the release. And that is considered very onerous by a lot of employers. So instead, they apply a window period at the end of the release. So they say that if you can release all the claims within 90 days of a date, and that would comply with the DIA requirements. the age discrimination requirements that Madeline has mentioned. But you need to then provide that the payment can only be made in the second year of the release. So in other words, the problem that the IRS is perceiving here is that the individual can pick the calendar year that the payment will be made. So they're trying to fix the calendar year. And they can do that by saying it's only payable in the second calendar year.
Maura Ann, is there any other points you would like to make about how a business should go about paying COBRA benefits?
No, I think the COBRA I've pretty much covered. I should say that the COBRA payment, you can limit it to 18 months of payments. It must be reimbursed by December 31 within 3 years after the termination date and can only be made for expenses incurred by December 31 of the second year after the termination date. So there are some requirements on COBRA payments, but the COBRA payments can absolutely be made. The only problem is you do not want to pay a lump sum that is not tied to the occurrence of some kind of healthcare expense. That's where the IRS comes in and says, hey, you could use the COBRA payment for anything. So therefore, we are not going to allow you to claim it's deductible. It is not deductible. As a general rule, foreign income does allow deductible expenses to be deductible medical expenses to be excluded from income. But only if you tie it to a fixed date.
Okay, great.
And I should add that the problem with 409A is that the expenses of the penalties are very onerous and they only fall on the individual. They do not fall on the employer. So the problem is here you've got an executive that you're trying to encourage to stay with you, who maybe is leaving and you're providing severance to him because he's a really good guy and you really want to hang on to him and you don't want your rest of your workforce to be worried about this. And as a result of that, he ends up with a 409A violation where all the penalty falls on him. You don't want anything like that. And the slap on the wrist for the employer, because it's really just a FICA withholding obligation for the employer. But the employee will end up paying a 20% excise tax. It will be includable in income. These all aggregated payments, includable in income, 20% excise tax, and then also a standard an income factor tax, as well as other penalties. So it's a very onerous provision for the individual.
Okay,
Hey,
let's move
Amy,
on.
I think that
Yes,
we
go
skipped
ahead.
a few slides.
Yep,
When
what do you want to go
Morgan
back to?
had, so what else should be included in a separation agreement?
Yep, let's go
Morgan
back.
jumped in on 401,
Okay.
409A. So I just want to make sure that we cover this. So the question of what else should be included in a separation agreement. So all separation agreements must comply with all local, state, and federal laws. Illinois separation laws can vary significantly from other states' processes. So it's really important to do the research and ensure your separation agreements are drafted accordingly, or reach out to an attorney for help. If you're not familiar with these specific employee termination laws, it could really put your organization at risk and invalidate some really important parts of the contract that you were hoping that would be enforceable. And don't forget that the laws are ever changing, so we recommend not really relying on outdated releases as templates. Besides these general contract formalities, such as governing law and jurisdiction, severability, waiver and amendments, competency to contract, etc., separation agreements should include terms regarding the Illinois Workplace Transparency Act and Illinois Freedom to Work Act requirement that employers provide all employees with 21 days to consider signing a severance agreement and a 7-day period to revoke their signature after signing. This is the kind of language that we would put in all caps and bold, either at the beginning or the end of the agreement right before signing. So another one is, if applicable, the Older Workers Benefit Protection Act that I was talking about earlier. that requires that all severance agreements with workers who are 40 years of age or older have certain language and disclosures in the agreement. Another one would be termination of health and other benefit plan coverage, just to ensure that the employee is aware that their health and benefit plans under the company plans are no longer going to be in effect or apply to them post termination. Another really big one, if it's not in another contract, is return of company property within a specified time period so that the employee cannot receive severance without returning company property. So I've had some situations where an employee or employer didn't put return of company property in the agreement, and like an employee will go ahead and either keep the computer or completely erase the computer and all the data that was on there before returning it, and you lose so much out of there. So this is a really important one. Another one to make sure you include is compliance with other agreements between the employee and employer with terms that are, to last past employment, if possible. So post-termination conditions. These type of pre-existing agreements can take many forms, including offer letters and employment agreements, severance incentive, health or retirement plans, confidentiality and other restrictive covenant agreements, which I'll talk a little bit more in a second, riders, addendums, amendments, employee handbooks, and workplace policies that don't have disclaimers in them saying that they're not a contract, or more informational exchanges such as emails or even oral promises. It's also possible at this stage to ensure that all other past agreements come into compliance with current law. So let's say you have a confidentiality and restrictive covenant agreement with your employee that didn't have the requirements that are required by the Illinois, the Illinois statutes, requiring either 14 days to review in writing. You have to let your employee know that they should, or that the employer recommends that the employee consult with an attorney, things like that. So we can take that and reaffirm with the proper law in the severance agreement. So that's kind of a fun one there. Out of many additional clauses that we would recommend, I wanted to point out a few others to consider, including an acknowledgement that the company already paid and the employee already received all accrued wages, PTO, bonuses, etc., that they are required to be paid upon termination. In Illinois, all wages earned through the date of termination must be paid no later than the next regular payroll date following the termination date of. So generally, this is 14 days. Depending on whether your employee works from Chicago, like I was talking about earlier, PTO may or may not be required to be paid out upon termination. Things like bonuses should be mentioned here too, if there's a policy on payment of bonuses at termination. Another one would be employee representations that the employee did not commit any violations of law, company policy, or the like, obviously excluding circumstances in which there was any policy or law violating incident that the employee was not terminated after. Another one is what happens if a party breaches its obligations under the agreement. So like the method a party may use to seek relief, costs, attorney's fees, etc. Without that, there's no contractual right to relief of costs, attorney's fees, unless it's statutorily required or allowed. Another one is language regarding the employee's protected rights under law, such as filing a charge or complaint with the EEOC, National Labor Relations Board, OSHA, the SEC, or other federal, state, or government agencies. Last, I wanted to mention, if we're not already having restrictive covenants in another agreement, such as non-competes, non-solicitations, non-disclosures, non-disparagements, and assignment of invention clauses. This can be placed in the severance release agreement. These are critical limits on how the employer may behave in the months or years after leaving employment. So want to go over what each of these mean real quick. Non-competes limit where, how, or for whom employees can work after they leave their employers. Non-solicitation clauses try to prevent a departing worker from enticing away other employees and contractors that work for the employer, as well as business relationships between other persons and entities and the employer. Non-disclosure agreements or clauses protect certain defined confidential or proprietary information and trade secrets from use or disclosure by the terminated employee for their own benefit. But if there is anything about confidentiality of a company's proprietary information or trade secrets in the agreement, always be sure to include a Defend Trade Secrets Act disclaimer, the key one. So non-disparagement clauses, they prohibit the departing employee from making disparaging and defamatory statements about the employer and its management. Many times we'll see this be mutual. The employee will want to ensure that upon signing this agreement, the company won't disparage or make any defamatory statements about the employee. Assignment of invention clauses. Now, these ones are fun. These clauses automatically shift ownership and right to any invention the employee created or helped create during their working hours, using company resources and information, and even those that relate to the company's actual or anticipated business research or development. So takes those rights away from the employee and puts them directly in the hands of the employer. And this is different from works made for hire, which is a statute that already requires works that are made for hire under the that federal statute go to the employer. Every state has its own test for whether restrictive covenants, especially non-competes, are enforceable. For example, in Illinois, like I was discussing, including non-competition and non-solicitation clauses in the agreement with an employee, the employee must be given at least 14 days to review and sign and be informed in writing by the company that the company recommended the employee seek legal advice of the attorney prior to signing. But don't forget the longer review period requirements we just spoke about in the Older Worker Benefit Protection Act. And I just want to note that the FTC, the Federal Trade Commission, is currently seeking to ban all non-competes, likely including non-solicitation clauses, from agreements between employers and employees except in limited circumstances. This outcome is yet to be determined, but as the rule has been enjoined by courts and is currently undergoing appeal by the FTC. And we're also not yet sure of where the Trump administration stands on this issue.
We are right at time, ladies. So if you want to wrap it up by doing any sort of conclusions or what I would like to call to-go cups for our audience, give them a couple of key takeaways from our discussion today.
Okay, I will apologize because I realized in looking at the chat box that somebody asked me whether I was talking about 409A of the Internal Revenue Code. Yes, that is exactly what I'm talking about. It's Code Section 409A of the Internal Revenue Code of 1986, as amended, and their regulations under that code section. I would tell you that the one thing about that is just be prepared and make sure you've looked at the impact of Code Section 409A on any plan, any document that you're signing, because it can be a very penurious code provision. And it's very broad reaching. 409A is incredibly broad.
Madeline, anything to add?
I'll do a few concluding words. So it really is a simple fact. Businesses, both large and small, need to protect themselves from risk, especially that involved with an employee's relationship severed from the company. Risk can take the form of physical risk, information risk, privacy risk, contract risk, etc. And one of the best ways to really protect your business from risk in this situation is by using severance release agreement.
For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher and Holland's Employment Law Lunch and Learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.